very determined gay lawyers headed by Evan Wolfson, who recently got married in New York after a long, long wait, decided that the path to follow in this country, this is 1993, was to achieve marriage rights. Well, at that point, overwhelmingly, sort of the gay advocacy movement was focused on getting Bowers overruled, not really confronting marriage at all. And among the sort of more general public, and certainly within academia, especially within academia, the idea that gays, recently sort of liberated and suddenly on the radar screen, would organize and devote themselves to seeking access to marriage was regarded as totally ludicrous. And not because the law didn't allow it, but because ideologically it seemed like such a cave-in, so regressive, so reactionary. Here was a chance for human sexual expression to take on a whole new dimension, with gays leading the world in a non-marital, liberationist, who knew what direction. And so, meanwhile, Evan and his little band are there in Hawaii, and they get a ruling from the Hawaiian Supreme Court that it violates the Hawaiian Constitution to exclude gays from marriage. Now, that decision was then overruled by the first of what have become the history and tradition of popular initiatives. But before it was overruled, it was sort of up and down and around, there was this cry of terror from a lot of conservatives, particularly a lot of conservative churches and denominations. We must put a stop to this. And so the 96 Defense of Marriage Act, both parts of it, were offered in Congress as a way to preempt and protect the nation, protect marriage as we have always known it, against the possibility that there will be another Hawaii. So Hawaii actually goes away, and then we get the Defense of Marriage Act. But at the same time, the U.S. Supreme Court confronts a case called Romer versus Evans that involved the question of the constitutionality of an amendment approved by popular referendum/initiative in Colorado. This amendment to the Colorado Constitution essentially wrote gay people out of the civil polity. That basically the state and municipalities were free, under the terms of this amendment, to discriminate against gay people in housing, in education, in employment, in public accommodations, everywhere. I mean, basically, go away. Or if you want to go on living here, don't expect to be treated like a citizen in the state of Colorado. Well, this amendment was challenged constitutionally, and it ends up before the Supreme Court of the United States. And guess what? This is the court that had decided Bowers in 1986. And now, although I don't have it up here, Justice Kennedy, writing for a very divided court, writes an opinion in Romer that says this amendment, which essentially writes a disfavored minority out of the possibility of participating in civic life within the state of Colorado, can't be the result of anything other than animus, anything other than hatred, anything other than disdain, and a desire to marginalize and exclude. There can't be any other explanation for this. And he does this, though, not by announcing that sexual orientation is a protected class, doesn't go there at all. Not by announcing that this amendment has to be subject to strict scrutiny, not at all. But he says under the lowest level of constitutional review, the most deferential, the so-called rational basis review, where the court basically bows to a legislature and says any crazy reason that anything remotely plausible that you dream up for a piece of legislation, we are kind of going to accept, as long as there's some plausibility, some kind of connection between it and the possibility of achieving a plausible objective. Kennedy says, even on the most deferential level of review, this will not pass the smell test. There's just nothing here except animus and hatred. Well, this is like quite remarkable. I mean, like, where did this come from? Now, it's true the amendment it is quite a hideous, absurd, nonsensical notion of basically slicing out from your population a subset and saying, you can live here, but don't expect to participate as a citizen of Colorado. But the fact that Kennedy invoked the Equal Protection Clause in a manner that reminded people, actually, of the way Warren had used the Equal Protection Clause in Loving. Basically, on its face, there's something really wrong here about this amendment. It's just hateful. But Kennedy doing it, not through strict scrutiny, but it just can't withstand any level of constitutional scrutiny. Well, Romer v. Evans then becomes the sort of basis for what is much talked about nowadays in the context particularly of this federal court litigation challenging Proposition 8. It is the central hook. Yeah. More. Couple. Yeah. In Colorado, Romer, R-O-M-E-R versus Evans. It's quoted all over the place in Walker's opinion and in the excerpts from Walker's opinion in the Prop 8 case that I came. And the reason I emphasize it is that it's really the launching pad for Walker's approach to declaring Prop 8 unconstitutional under the federal Constitution, meaning that Walker ends up declaring Proposition 8 unconstitutional for failure to meet even the rational basis review. And what the Romer sort of standard has come to be characterized as a kind of rational basis with bite or rational basis plus, suggesting that rather than keel over with deference to what a state has done, simply because the state has done it and concocted some kind of reason for it, that even at this most deferential level of review, the obligation of the federal courts is to ask whether there is something here other than moral disapproval, a disdain, and a desire to marginalize or exclude from the enjoyment of human or civil rights a disfavored minority. So Romer and also Lawrence become central to this contemporary litigation. But in Lawrence itself, which overrules Bowers, one of the most remarkable things about Kennedy's opinion is that it's kind of bad poetry in many ways. I mean, it's filled with rhetorical flourishes that could mean anything, but they could also mean nothing. But that after a lot of open-ended love song to the notion of personal liberty, as in this paragraph, liberty protects the person, not just within those private dwellings where you have two adults involved in consensual sexual intimacy with each other, which can no longer constitutionally be criminalized. He articulates what is at stake here as going beyond this tangible, behind closed doors, consensual sexual interaction, and links it to those spheres of our lives that go beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case, which is whether homosexual sodomy can be criminalized, involves liberty of the person, both in its spatial, behind closed doors, and more transcendent dimensions. Well, kind of what is that all about? Later on, though, he begins to circumscribe the scope of this transcendent personal liberty and autonomy interest. Very specifically, in overruling Bowers, the decision is that the state may not criminalize this behavior between consensual adults. But the fact that the state may not criminalize it, does that mean that a state has to affirmatively protect relationships between two men and two women that are expressing their desire to participate in both the spatial and transcendent aspects of freedom, personal liberty, and intimacy? Does this mean that the state has to open marriage to same-sex couples? And basically, he and O'Connor and the other members of the majority in Lawrence, which clears the way for everything since then, but basically at the end of their opinion, they make crystal clear in response to the marriage question, oh, hell no, we're not talking about that. That's something else. That's an issue of an affirmative obligation by the state that's not, it's not here. So the case involves two adults, mutual consent, sexual practices common to a homosexual lifestyle.